has clubbed all of us here for the first national workshop on doctrinal legal research methodology. The workshop is planned into two series, therefore, doctrinal and empirical legal research. In the first series, we have focused on doctrinal part in order to give in-depth understanding of research basis on case studies and literature already available. Thus, the workshop intends to provide an opportunity to participants to broaden the horizon of their knowledge in doctrinal legal research as well as to enrich their skills in conducting quality research. Now, I would request Professor Dr. Mahesh Kulwal, Dean, School of Law, JECRC University, to deliver a welcome address to our guests. Over to you, sir.
Thank you, Kamal. A very warm good morning to one and all present here. I, Dr. Mahesh Kulwal, Dean, School of Law, JECRC University, welcome all dignitaries on the dais and all the participants. I would like to welcome Professor G.S. Vajpayee, Vice Chancellor, Rajiv Gandhi National University of Law, Punjab, Professor Sanjeev Sharma, Dean Research, JECRC University, Jaipur. Sir, first of all, I extend my hearty welcome and thanks for sparing your valuable time for this workshop. Sir, you know well, in the law, most of the research is a doctrinal research, and we also took this topic in this line. And your knowledge, Vajpayee sir, your knowledge, vast knowledge in the research field will definitely benefit all participants. Sir is well known in the research scholar and all the previous vast experience. And sir, I would like to remember just to call you that we have met you 10 years before when Professor Mulchan Sharma was the Vice Chancellor in the National Law University, Bhopal, and you were also one of the chief guests and the key speaker in the clinical legal method workshop was conducted. I don't know whether Vajpayee sir will remember this or not, but again, I welcome you, sir, from the bottom of my heart. And Professor Sanjay Sharma is the chief architect and the planner of the research plan and the policy of the JECRC University. Sir, your address will definitely benefit our research scholar, because my all 14 research scholars are participating in this workshop. And besides your knowledge and other experience, you will also share some procedural point, because there is a lot of confusion. What happened, whether we should do this or not. So I would request additionally, Sharma sir, that you will also add on this point also. Last but not least, I would like to welcome the honorable speakers for the event and all delegates. I wish all the best to all my participants. Thank you once again, and thanks once again. Thank you, sir.
Thank you, sir, for your kind words. Being a student, I feel delighted to take an opportunity to introduce Professor G.S. Vajpayee. Professor G.S. Vajpayee is a professor of law and currently the Vice Chancellor of Rajiv Gandhi National University of Law, Punjab. Sir has more than 30 years of professional experience as an author, researcher, teacher, and administrator. Sir has authored 21 books and more than 50 papers. He is also the editor of 2 prestigious international journals. Also, he has been appointed as a convener of Committee for Reforms in Criminal Laws set up by the Ministry of Home Affairs, Government of India. We welcome you, sir. Now, I request sir to enlighten the participants. Over to you, sir.
Very good morning, all, and thank you, Professor Mahesh ji, for welcoming me to this important gathering. Professor Sanjay Sharma ji, and Dr. Namita Jain for inviting me to this gathering. I was a bit tight with some issues going on in terms of meetings here and there. However, when I was insisted, so I realized that as a teacher, it is my duty to spare my time to this important task. And especially when it comes to research method programs, I feel rather more committed to it. And therefore, I am with you today. However, my task is very limited in terms of what I am going to say, because I am a firm believer of the fact that uh, in the present mode in which we are sitting is not really an ideal mode in which research methodology can be discussed, debated, and analyzed. However, we have to carry it on, and therefore I'm just making some introductory remarks. I'm very happy to note that you have decided to focus on doctrinal legal research. As has been mentioned, that majority of legal research by nature inherently is qualitative, or it deals with qualitative information, and therefore the doctrinal methodology becomes more suitable. For the understanding of the young scholars and students who are assembled here today, I'll be just making a couple of introductory remarks to set the tone for this workshop in the beginning. So when we talk of doctrinal research, it means essentially we decide that there is a qualitative material, or there are certain doctrines in law which need to be explored or which need to be analyzed. However, the doctrinal method doesn't end here, because in most cases when I interact, I ask what is the methodology you are adopting. The students are likely to say that they are using doctrinal methodology. But what is that doctrinal methodology? Beyond this, they are unable to probably say anything. So what are the techniques in doctrinal methods? Method and techniques, there are two different things. Method is a larger approach, and there would be certain techniques. So until and unless you come down to the specific techniques, you will not be able to apply doctrinal method, because simply saying doctrinal research is we are doing doctrinal method, that is not enough. Another misconception is doctrinal method is sometimes confused with library research. They say that we go to the library and collect the secondary material, and that is the doctoral research. I think as a teacher, these misconceptions need to be dispelled at the beginning itself. So visiting library, collecting the material, compiling it in your computer, and summarizing them is not essentially a doctrinal research. That is my first important remark. Now, if it is not doctrinal, then what is the doctrinal research? So I would just try to differentiate between doctrinal and non-doctrinal in most simple way. So there are two types of situations we have. One, I call it research in law. Another, we call it research about the law. I think you can note down these two things, and you will always be either doing research in law or you are doing research about the law. When you are into research in law, you are likely to adopt a doctrinal kind of method, where you are specifically examining the doctrine in a particular manner, and what are the techniques, I'll come to that. But this primary understanding means we are only looking at the constructive or the structural aspect of the law within the law. We are not looking at the external factors influencing the legal process, legal phenomena, or legal paradigms. Though there is influence of external factors on all kinds of legal process. But here we are essentially exploring the understanding about that doctrine within the law. Research about the law is essentially about appreciating the external factors which are not really located in the law, and how those factors influence is something about non-doctrinal, empirical, or quantitative research. Generally, research about law is about appreciating the factors which are away from the law, but are becoming quite crucial. So like, for instance, if I say that the number of cases decided by the court are influenced by both the issues involved in the law and issues outside of the law. If you are able to give this example to your students, so what are the issues which are purely legal? They are the law related matter. Means there are specific provisions in the law which might lead to the delay. Like, for instance, section 309 of CRPC, there is a process of adjournment. So adjournment is one of the factors leading to the delay. If your researcher is actually examining the adjournment and nature of adjournment and way it happens, actually it is a doctrinal kind of study, because you are exploring the legal processes, legal pursuits, and not really. But there can be a situation, you are looking at the number of judges, you are looking at the infrastructural facilities, you are looking at the distances of the court from the population area and all that. These are the factors which are not purely legal. However, these factors do have some bearing on the type of delay that happens in the court. If you are able to perceive these two situations clearly, then you would be knowing the nature of doctrinal research in a much better way. So please try to look at whether the research scholar is trying to appreciate the pure legal factors which are located within the law, or he is trying to look at the factors which are like media trial impacting the legal adjudication. It is a law about research about the law, means how law is being influenced. So these are the socio-legal research or empirical research, whatever you call it. Another distinction I can put forth, which again would bring a lot of clarity. It is also mentioned whether it is qualitative or quantitative research. Please remember, when I say qualitative research, means I am essentially indicating the nature of the subject matter involved. So subject matter of law is essentially, most cases, it is qualitative. So if I am studying, suppose, the competence of lawyer, or if I'm looking at the process of cross-examination, or if I'm looking at the process of plea bargaining, and any other thing which I am looking at, these things are qualitative in nature. So content, if your research is about exploring the qualitative content, then doctrinal and qualitative, these two things go together, because doctrinal research mainly deals with qualitative stuff. So doctrinal, qualitative is one model. Empirical, non-doctrinal, and quantitative is another model. So tell your student that doctrinal, qualitative, non-doctrinal, empirical, quantitative. There may be some overlapping here and there, because a research cannot be purely doctrinal or purely empirical. There may be a mix of, so that is the third category. So please do not compartmentalize very sharply all these things, because there may be a case where you are also trying to look at the quantitative data, because this time we have a lot of tools and techniques to collect the quantitative data about the stakeholders. Another example, which would again, so the choice of method is essentially guided by the nature of research that you intend to do. Please remember, choice of method is guided by the nature of research that you intend to do. It means before you commit to use any particular method, you need to assess what is the demand of your research. So if your research is demanding to have some data which is empirical in nature to be collected from the stakeholders, so whether your student or your supervisors are able to understand that what is the demand of the data, what is the need of the data for the kind of research questions you have posed. Please try another remark. You can note down. I'll number it. Probably I have said 3 things. This is number 4. Number 4 is reading the need and demand of the data as entailed in your research question. How to read the demand of data through your research objectives. So to be able to satisfy your research objective, you may need to collect certain data. So like, for instance, if I say, I want to understand the impact of Prevention of Domestic Violence Act. Suppose this is an. So in order to study the impact, I have to actually do an empirical kind of a study, because the stakeholder would be involved. So wherever stakeholders are involved, like prosecutors, police, victims, witnesses, these are the living sources of the data. And you can collect the quantitative data through questionnaire or interview through them. So this model would essentially be quantitative empirical model. However, if you want to understand the perceived victimization or perceived understanding of the victim regarding the Prevention of Domestic Violence Act, how do they understand? They may come out with a variety of narratives, and collection of this narrative essentially take you to the qualitative stuff, which is doctrinal. So if I want to, I'm just giving an example, doctrinal. If I want to evolve the perceived sense of justice of the victim with regard to Domestic Violence Act, I need to collect the ideas, experiences, narratives from the victims. And those would be qualitative experiences. They would be telling you that this act is not useful, this act is too outside, this act is too foreign to them, this act doesn't actually go to the root of the problem. And therefore, you will find that these qualitative expressions can be summarized into some kind of a doctrine will be evolved, which will be the perceived sense of justice. Now, perceived sense of justice is a doctrinal outcome of the research. I hope I'm able to convey clearly. And so therefore, a researcher needs to be guided to understand the type of data is being demanded by the study that he or she has undertaken. And therefore, I also say proper queries need to be formulated. Actually, a right question would fetch a right answer. If you are unable to formulate a right question for your research, you are highly unlikely to get a precise answer. An ability to formulate the research query is the hallmark of everything. We continue to be vague with our research models because you have not posed clear questions. A clear question would clearly demand the kind of data that you need to substantiate that question. I hope you understand. So training is needed that you pose doctrinal questions. So like, for instance, I want to understand, another example I'm giving. I want to understand how the doctrine of criminal responsibility has evolved over a period of time. Because we have a different idea of criminal responsibility in case of a child, in case of a woman, in case of aged, in case of provocation, because there are a lot of general exceptions. All these things have evolved over a period of time. So suppose a researcher intends to do that, the way doctrine of criminal responsibility as it happens in 21st century, how it has evolved over a period of time, and what were the factors, how it was shaped, and what are other things. You can easily do it by surveying the literature and bringing the material, aligning the ideas, and creating a new knowledge. I'm telling you, this is a fantastic journey. Doctrinal research is really difficult to do. People have this experience that probably the quantitative empirical is difficult. I say doctrinal research is difficult. And a lot of people are claiming that they are doing doctrinal research. It's not really a doctrinal research. They are compiling the material. But ability to draw the inference. So like, for instance, if you are reading 5, 6 publications with regard to a particular doctrine, any doctrine in the law, are you able to draw a new inference from the conjoint reading of several pieces of work. And if that happens, now no research method book tell you how to do that. No research method book tell you how to do that, because the best way to learn research methodology is to do the research. There is no other way to do the research. So I think over a period of time, with the growth of experience, one would be able to read the material conjointly to be able to draw a new inference. Sometimes a new inference is drawn, and you can then probably dovetail that new inference to create a new set of understanding with regard to the existing phenomena. And it has happened in law very often. So like, for instance, copyright and copyleft. Copyleft movement is now gaining ground. People are saying, because it all started with copyright, and copyright doctrine was dominating over a period of time. Now people are saying copyleft means you need to increasingly make the things freely available to the readers instead of being too rightful on the copy issue and inviting violations. You need to make that's why there is an open access movement in law. There's a trend that all the material should be made openly available. So there are a variety of things. Now, if I give you a lot more formal understanding, I mean, how can you read some of the things through the doctrinal research in terms of knowing its meaning or in knowing the basic idea? I said that research which provides a systematic exposition of the rules governing a particular legal category, analyzes the relationship between rules, explains areas of difficulty, and perhaps predicts future development. That is the doctrinal research model. So it involves basically analysis of cases, number one, case law, arranging, ordering, and systematizing legal propositions. Please remember. So suppose I want to study, I give you another example, which I have done. I wanted to check my hypothesis. There is a hypothesis also. So suppose I'll just give you an example of doctrinal research which has been published and which I have done. And then you can probably relate. And then I'll give you the definition. So if I say, I read somewhere that there is a doctrine of victim blaming, victim stigmatization. So victim blaming by the court is a recurring phenomenon. So idea of this is that there is a ample of evidences that at different stages of trial, a crime victim tends to suffer different kind of sexist notions by the court officials and all other functionaries. So my hypothesis was that a victim of sexual assault experiences victim blaming during the trial. So suppose, do you understand what I said? So this is my hypothesis. Now, victim blaming is a kind of doctrine. It's a concept. It's a conceptual thing. Now, how often it happens during the trial was something I said in the beginning that a clearly stated proposition would clearly demand the kind of data you would need to substantiate this. So now, can we read that what kind of data I need? So I need to look at the cases in which victim blaming has happened. And through that, I would try to know the type of victim blaming, the response to victim blaming, and the experiences of the victim while being blamed. Now, what I did was, I collected the case laws where there were instances of courts evaluating the conduct and character of the victim of sexual assault and casting aspersion of certain kind, blaming the victim for the victimization that she has suffered. And I have mapped all those places, all those instances. And after doing that mapping, I have collected the ideas and information whereby I could create a table highlighting the number of cases in which the victim blaming has happened. So what I said, doctrinal research involves, please remember, analysis of case law, arranging, ordering, systematizing legal propositions. So I have done basically the arranging, ordering, and systematization of case law to be able to draw clear ideas with regard to victim blaming. So I can draw same ideas if I have a different topic. So topic has to be in your mind. What doctrines? If I say courts are pro-death penalty or anti-death penalty. So doctrine of being pro or being anti. If I want to examine this, I can look at the cases and I can map those opinions of the courts where court has said something like that. And then we'll try to see in the end that after 100 cases, what is the pattern which is emerging. So in the end, I would be in a position to conclusively say that the courts are growing pro-death penalty or anti-death penalty. Or here, the courts are creating sexist notions against the victim. And this analysis is essentially doctrinal because I am not doing any interview. I'm exploring the literature. See, legal research typically involves exploration of the literature. And exploration of the literature cannot be tentatively done, please remember. It has to be systematically done. And therefore, literature review as a tool is something which you must come on. How to do the literature review is, I don't have that kind of time, but literature review can be as systematic as anything. And a very well carried out literature review would lead to a better organization of doctrinal research. I also say in doing doctrinal research means research that has been carried out on a legal proposition or propositions by way of analyzing the existing statutory provision and cases by applying the reasoning power. So reasoning is very important. Now, why it is done, I think this is also important. So sometime and the present state of achievement. So like, for instance, the policy goal. So the policy goal of domestic violence or PCA, Prevention of Corruption Act, in the state of achievement, whether the objectives are being achieved by the law or not, that gap can be studied doctrinally. Second, availability of alternative choice for the implementation of goal. So are we in a position to say that this law is not good enough or this legal provision is not effective enough? Third, prediction and consequences that were made in a dynamic society. What are the predictions? And fifth is the gaps in the statutes and the court have to evolve doctrinal principles, standards, and norms. So sometimes the statute and the court reasoning, there are lots of issues. So we have to look at this ambiguity in the law. Therefore, doctrinal research, let me say, summing up, mainly it is qualitative. Second, it is distinctive because it's very unique in nature. Third is it is undertaken according to accepted discipline standards and rules. So in a law, we have a typical way to examine all these things. And it requires certain skills on the part of researcher to explore or to derive inferences. It is called a higher level critique. Please remember, doctrinal research entails a higher level critique. First order critique, second order critique. We need to know because here doctrinal research involves a critical reasoning. I'm telling you why researchers, young researchers, invariably fail to actually apply doctrinal research, because by reading a piece or by reading many pieces, you need to develop your arguments by applying critical reasoning. because new knowledge can only be created when you are able to critique it. And criticality results into the generation of fresh arguments and alternatives. I don't know if I'm able to really pinpoint it, but I think what I'm conveying should be clear to you. And these things are, I'm telling you, utmost important research skill for a law researcher. Because if a law researcher doesn't know how to apply reasoning, a number of reading of the material would not result. That's why the students are sometimes very apathetic to read, because reading, a plain reading, how to read is also very important. I think I leave this thought to you, how to read. Reading is not simply a mechanical, flipping of the pages and reading line after line. No, every paragraph that you read, it must change something in you. And what is that? So like for instance, it is a sparking. So if I read a sentence, it should cause some spark in me. And that spark should be noted whether it is leading to a new argument or a new insight or not. Otherwise, same, if the insight remain constant, means if you are conforming to the content simply, means you are just going along the content. No new knowledge is actually being created. So therefore, the contextual background, it's very important. Doctrinal research is contextual, and it needs a guiding principle and hypothesis. You should have a hypothesis also. So all these things taken together would lead to a fundamental change in the way we are producing. I know that the state of doctrinal legal research in country is absolutely dismal, not because the students are not trying to do, but because we do not have trained manpower to really orient the students into the sound legal. Now, there is a lot of data available, a lot of publications are coming up. So like, for instance, I have just mentioned, I couldn't mention the techniques, but I can just mention that if you are making observations, if you are making participant observation, non-participant observation, content analysis you are making, you are doing a discourse analysis, you are doing a narrative analysis, you are doing a meta-analysis, you are doing an analytical induction. These are the techniques. If you are recording me, I think you can search for the material. There is available material. So for instance, content analysis. So instead of just being very tentative, can't you do a content analysis of 10, 15 cases to evolve something new? You can convert the text into data. Then you can do meta-analysis. Meta-analysis is a conjoint reading of several ideas which are the part of various writings, and how you can, you are trying to draw the inference out of collective inferences. So art of drawing collective inferences. Then I'm saying analytical induction. So while reading the text, because qualitative research, actually data collection and data analysis happens together. So are you able to apply this analytical induction in a way which is becoming useful? And also discourse analysis or narrative analysis means the ideas being communicated, grounded, because I don't have time. The grounded theory is the basic idea in qualitative research. So some of these ideas will be very, very important. You can explore some of these ideas. And I'm sure that a competitive researcher, especially in doctrinal research, is much needed in Indian context. That's why we couldn't evolve new theorization, new conceptualization, despite the fact that a lot of new publications are coming up, but rarely they are deploying a clarity of much needed clarity in this regard. So I think this is all from my side, and I wish you all the best. I'm sure that this workshop would lead to your capacity building into the use of doctrinal research, and especially there are softwares that are now available, Atlas TI and all that, which are becoming very, very useful. And I'm sure this initiative will go a very long way in ensuring that there are people and there are groups, there are experts who would be giving more and more attention to this. Thank you for having me today. Thank you from my side.